Hello and welcome to episode 2 of the Burch Law Pegasus podcast, Burch Law production. What did we come up
Yes.
Yes.
with? Yes, all of those. Okay,
Pegasus
fantastic.
podcast, a Burch Law production.
A Burch Law production. Soon to have t-shirts. Before the first episode even dropped, we had requests for t-shirts. That's a good sign, I think. Anyway, the podcast is called, and it's really the whole reason I started the podcast. One of us knows what they are talking about, and the other one is you. Episode 2. And today we're going to talk about probate. What it means, what it's like, how to avoid it. Do you want to avoid it? And we'll cover those topics. Maybe anything else you want to avoid. I don't know. But we're going to talk about that, hopefully demystifying a lot of the misperceptions and misunderstandings when it comes to the world of estate planning and probate and life, I think. Yes. And, look, the title is tongue-in-cheek, and it comes from frustration that I think a lot of people who are in a particular industry that they feel when it comes to others who think that they may know better than you do. And so we're having fun with it. It's meant to be fun and educational and, dare I say, thought-provoking, which Sara would define as provoking thought.
That is correct.
Yes. So I do want to get some clarification, though, because I did notice that Sara Gibson, our marketing coordinator, Sam Anderson, home of the famous flapjacks, and also administrative assistant, and Cyntia Frederick,
Yes.
operations manager, managing the operations of the firm, are all with Burch Law. We will probably have other people join us, but we will never not have us, right? Are we all committed to this?
Yeah.
I do think at one point we really do need to explain the flapjack situation, but that can be for later.
Oh, you want to bring that up now? Look, it's really not.
Except for later.
It's not that complicated. I just think Sam Anderson sounds like one of those like 50s diners, or like a Denny's or something, and be like,
like Jim's in Austin.
Yeah, or like the Howard Johnson. So it's like the Sam Anderson, home of the famous flapjacks. I don't know. It just sounds like that to me. Maybe I'm alone in that. But anyway, Sara, our marketing coordinator, coordinating the marketing, has come up with this hashtag for one of us knows what they're talking about, and the other one is you. And apparently, and this is first time, this is a huge risk. I don't know if I really should be doing this, but we're going to do it. Sam and Sara have been pronouncing it.
Yes,
or
they
what are you
have.
doing?
Yes.
Okay. All right. Which has got to take longer than saying the actual title itself, but I want to hear it.
Well, I have to find how Sara wrote it because I don't remember how she did
It's Ukwatata and Tui.
it. Ukwatata and Tui.
So, Lorie, I don't know if
I don't
last
understand it
week-
with your accent, Sam.
Last week, after we recorded.
Oh wait, I need
Thursday.
a moment. I need.
Oh, they were like sitting in Sarah's office and just laughing their heads off. And I walk in there, I'm like, do I even want to know? And Sara says it. I'm like, I need you to repeat that. What? And then they just like die laughing, apparently.
It kills me. It's great.
Not to be confused with Ratatouille.
Okay, say it again.
Thank you, Sara.
Ukawatata and Tui?
Close.
I hope that we're not like summoning
Close.
some demons or anything by saying
That's
that.
you have some eldritch horrors that are about to pop up.
Don't say it 3 times. Okay.
They're making a Beetlejuice too.
They are. The trailer came out, I think, like last week.
Yeah.
I do. So you all get the joke I make when a previous difficult client calls and I'm like, oh, who said their name 3 times to make them call? You get that reference? Oh, good. That's so warm and fuzzy. All right. So probate. Okay, everybody. So first of all, a lot of people don't know what probate is. They call it probation. And then they ask about getting an executioner appointed. So let me just clear up a couple things. it's probate, which is a court, and by the way, this is all specific to Texas, if we haven't made that clear. So probate in Texas is either a statutorily created probate court, which Sarah is what? A court created by statute.
Statues.
Okay. So clearly this podcast is just
Okay.
waiting for us. Okay. Anyway. All right. So
I pulled up a
yes.
definition
And
if you
then
want it.
and then smaller courts. Oh, good. That'll be exciting. Let me do one as a almost 20-year probate attorney, and then let's hear what hopefully it's from Black's Law Dictionary. But anyway, then other smaller areas, it's just the county court at law will also handle. So it's more a general jurisdiction court. And this is the court system that you have to go through when somebody has passed away. And we're going to dive into, do you have to go through probate? What are different types of probate? What does that look like? And then we do sometimes laugh because people call it probation. They need to go through probation. It's like, well, wrong kind of firm here. And then when people create a will and they appoint an executor, who is the person that handles everything, gets into the bank accounts, pays off expenses, transfers money, distributes assets, sells a house, transfers a house, all of that. That is the executor. But then sometimes they'll say executioner, and completely unironically. So interestingly enough. So Cyntia, you pulled up a definition of probate?
I mean, yes, it's sorry to disappoint, but it's the American Bar Association's definition. But I also pulled up Black's Law Dictionary. So which one do you want? Black's Law. Okay.
What does
The
your heart
act or
tell you?
process, yeah, the act or process of proving a will, the proof before an ordinary surrogate, register, or other duly authorized person that a document produced before him for official recognition and registration, and alleged to be the last will and testament of a certain deceased person is such in reality.
I think that just shows why I've been in business for so long, is because I'm guessing at this point everybody's like, I totally understood it when Lorie said it, and
Yeah.
that made no sense. It's also not complete because the definition talks about there just being a will. And so let's break it down into two different situations, because one of the things we will talk about is when you have a plan. So remember, our mantra around here is if you don't have a will,
The state of
State
Texas
state
has
of
one for
Texas
you.
has
For
one
you.
for you. Okay. Exactly. Right. So that's really, we could just define that as probate. So there are reasons you have to go through a court system and get a judge to approve things when there is a plan, when there is a will, sometimes when there is a trust. Ooh, what does that mean? We'll get to it. But let's start when there's nothing. Okay, you haven't, well, not nothing, but you've decided to settle for the state of Texas estate plan. So in general, and I know Cyntia may or may not want to interject on some of this, there's lots of different options, and it really depends on the family circumstances of the person who passed away, as well as what the assets are. But no matter what, it's going to be messy, ugly, time delays, more expense, but it just is what it is. So if you've got a house or you've got a bank account and there's been nothing done, there's no beneficiary designation on the bank account, there's no home or deed or trust or anything that says anything about the home, we got to figure out who the heck this is supposed to go to. So if somebody passes away, whatever they have needs to not be in the name of a deceased person anymore, including debts, by the way. So we always have to assess, okay, what are we going to do? Someone comes to us, someone close to them has passed away. And the law, first and foremost, with some exceptions, sometimes creditors and stuff can initiate this, but basically it's got to be an actual relative that does something. So it's going to have to be a spouse or an adult parent or another related family member that can do anything. So if your best friend passes away, or your unmarried partner and you're not common law married passes away, you actually really don't have much standing. Again, there's some asterisks, some exceptions here, not many though. Just in general, don't really have any standing to be able to bring any sort of case. So in Texas, we've got a couple different options, but over the last 5, 6, 7 years, our first episode, we were talking about dangerous trends. One of the trends we've seen is just probate in Texas has become exceedingly more expensive, more time consuming. And a lot of that is because courts and judges, and maybe this is a good thing. It really is. It was kind of the wild, wild west before, where basically they'd let almost anything get through the courts to make things easier. And so they really are clamping down on a lot more restrictions, a lot more proof, a lot more evidence. For example, let me give you one. I know we're talking about without a will, but let me give an example. If you have a will and it just says I give everything to my kids, but the will doesn't define who the kids are, previously, in the before times of 6+ years ago, also depending on the county, a lot of times we could file that, and then just through evidence, through testimony of the executor or whomever, they'd say, well, these are the 3 kids, yada, 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 and we're on our way. What we can see now, what's more likely to be seen now, is a judge saying, well, no, we got to get an attorney ad litem appointed. They've got to research the heirs. There has to be a finding, this, that, and the other. And all that just means more time, more money. That's really, really what it is. So without it, the highest level of what we can do is what's called a determination of heirship. I call it a DOH. What do people at Burch Law call it?
Does.
If anybody
Does.
couldn't hear her, we call it a doe.
No. Yeah. I don't know what it is, why I feel the need to say it and not pronounce it. I guess this gets back to the
Todd.
whole acronym. Yes. I've given into that one, the transfer on death deed. It's no
Todd,
longer it's a Todd now. But anyway, determination of heirship. And that's really 9 times out of 10, probably that's just going to be the better way to go. But that is actually the most expensive, time consuming way to go. But depending on assets, but it's where whomever is the family or the relative, the person that can do something, they got to shell out usually, 7,000 range. It could be more, it could be a little less, but we're probably looking in 2024 fees. It's going to at least cost that. They're going to have to apply to the court. The court will appoint, I mentioned this a moment ago, what's called an attorney ad litem, where they have to research the heirs, and which means that they're looking at obituaries. They're looking that you have to get 2 people who knew the person who passed away. More about that in a second. All the family members that you're listing as the heirs. So in Texas, heirs are defined as, if you're married, that's an heir. If you have kids, those are your heirs. If you don't have any of that, then it goes up to parents. If parents are living, if parents aren't living, then nieces, nephews, all of that. I love this, that I see Cyntia raising her hand. It says Cyntia has something to say. And it's like, you might as well just keep that up at all times. Like, we need that printed on the shirt.
I just need to. You said something that was interesting a second ago. It said that person
Hopefully
needs.
I've been doing nothing but saying something that is interesting.
I can keep it to myself.
Can you?
Yes, actually, I can.
No, just do it. Let's hear it.
Well, no, you said that the person would have to apply to the court, but they can't do it themselves. They must go through an attorney to do so. That's one of the biggest things in Texas, that a person cannot just themselves go forth to the courts and start this proceeding for it to actually come.
In a lot of things where you can do what's called pro se, like this is not one of them. Even if you have a will, which we'll get to here shortly, like you can't initiate that. Most courts are not going to listen to you. It is few and far between. And so anyway, it's this prolonged process, and then they all the heirs have to agree on who can be the executor, administrator, personal representative. They all have to agree. And so it's a lot of ifs. But if all that comes together, then they have to know what all the assets are. And, a lot of times family members don't necessarily know. Like, I don't know if they had a bank account. I don't know if they had a life insurance policy. Like, they just don't know. So it takes a lot of time to figure all of this out. And then the kicker is, there's lots of kickers, but then the kicker is that there's no choices about how things are distributed. It is purely according to the state of Texas and what is called intestacy law. And second kicker, all of this is public record. And then if you have three legs, the third kicker is I mentioned this earlier, but you have to have two people who knew you be willing to testify or swear in a statement or in court that they knew you, they knew your assets, they knew your debts, they knew your entire marital history, and they knew whether you had kids and what those kids were. All of that. There is no, listen to me now and believe me later, there is no option when you don't have a will, a trust, or an actual plan that does not include having two disinterested people testify, swear in a statement to all of the things about you, and then it's all a public record. It can how long is it taking now for us to even get a hearing before they can even do all of this once we file?
For termination of heirship, minimum 3 months.
No, I mean a doe.
You know, I can
The
see
way
the
I
comments
kinda
now.
think
Be
about
nicer
it,
to Cyntia.
it's like your dream come true, isn't it?
I know.
So I kind of the reason I do like doe is just because it's kind of like the Homer Simpson thing where it's like doe, right? Like you should have done a will, you should have done something. So there are some other things you can do sometimes, but they're becoming less and less feasible. There is a small estate affidavit, which a future episode we're going to talk about banks and the horrible things and advice that they give to people. And so often we get people who are like, oh, the bank told me I can do a small estate affidavit. And it's like, no, actually you can't. You can't do a small estate affidavit because you have a will. You can't do it if there is a will. You can't do it if the debts exceed the value of the estate. And right now, the threshold is $70,000 or less of what your estate is worth to do a small estate affidavit. But if sometimes it's a financial institution, they don't know what the other assets are. So they're only looking at the account that they have there. So, but there are things like small estate affidavits, affidavits of heirship. There's all these other things. But the bottom line with all of them is everything's a public record. It's going to take a lot of money, a lot of time. It's going to go absolutely according to whomever the state of Texas says that it goes to. Interesting fact, by the way, stepkids, which, some people, have blended families, right? In Texas, because we're a community property state, the default laws of Texas actually gives the person's half to their kids. So if you've got a married couple and the person who dies has kids from a previous marriage, without anything, those kids are actually going to get half the house, half the money, half of the community property stuff. So very, very messy to not have a will. But that's probably a little bit more than a nutshell because we've got some fun examples of probate gone wrong. And we like to think of ourselves as the CYA lawyers, the cover your assets lawyers, and we are saving Texans from the dangers of probate chaos. Kapow! So anyway, Cyntia, did you want to add anything to that?
Not right now.
She's thinking, for those of you who aren't watching the video.
Yeah, no, it was just mostly the making sure that people are aware. No, you can't just do this on your own. Much like you should not just draft a will on your own.
Yes. So one of the things that we're going to transition to now is talking a little bit about some of the horror stories. And so I actually want to tell a fun story with a determination of heirship that I had quite some time ago. And this was a situation where it was a parent who passed away. The other parent had already passed away previously. So it was a single person, 4 adult children. They all were in agreement. The stars were aligned. The brother who lived here in the Dallas area was our client. And we've got the 2 people that are willing to testify. We've got the ad litem. Everything's lining up. We're ready for court where the brother can get appointed so he can sell the house, so he can get into the bank accounts and distribute to all the siblings. And I'm sitting at my desk and I get a call from the ad litem, and he says, I know you said that there are 4 kids, but I've actually found 8. And I'm like, this has been the most vanilla, easy determination of heirship I've ever had. Like, you got, like, I'm like, oh, yeah, okay, whatever. Let me get back to you. So I call my client and I'm just like, hey, we'll change his name. Joe, you're not going to believe this. Just wait. This is some tomfoolery right here. Do you know that the ad litem said that he thought your mom had 8 kids? And I'm expecting for him to like just be there with me, like, oh, yeah, how ridiculous, how foolish, right? Instead, it's like this pause. And then all the first thing I hear is a big sigh, which I should probably have Sara do it because she sighs really well. Yes. I like freeze in my place. I'm like, what? And he said, well, well, when we were younger, we my aunt and uncle passed away, and therefore young kids actually came to live with us. And so, yes, I mean, in the obituary, we did say the 8 kids and all of this, but they were never adopted or anything like that. And I said, okay, well, give me the name of the 4 kids, their name and contact information, so the ad litem can call them. I'm not done with the story, by the way. Just hope you know. So the ad litem could call them, just confirm the story that they, weren't adopted and everything. Next thing I find out, one of them tells the ad litem, well, I really thought we were adopted.
What?
No.
And it's like, how do we prove 40 years ago in another state that someone was not adopted? Anyway, it ended up getting sorted out. The other siblings were like, you idiot, we were not adopted. What is wrong with you? And we were able to proceed and go through it. But just the time and expense and delays of all that. And that was pre probate going down the toilet in Texas. I can't even imagine what that would be like now. In the now.
You don't have to. That happened last year.
Yeah.
What do you mean?
No. Yeah. So I do want to talk about definitely some things that happen with a will, because wills and trusts that don't get assets connected to them still have to go through this exact same process. But Cyntia, do we want to transition any stories that we have, horror stories where there wasn't anything, or do we just want to dive into the really bad wills that we've had to deal with?
No, I want the flip side to what you said. So you had a termination of heirship, you're going through, ad litem calls up, kids, no, you're not actually adopted. So last year, one of our attorneys here, Morgan, was going through a case where we were doing a determination of heirship, and there was also blended family. They came to live like all together when they were all fairly young. So we're going through the process. We are getting right up to like the day before the hearing. Everything's going smoothly. Our client, which was the deceased daughter, or the decedent's daughter, she shows up to court, and they're about to go through the process, the prove-up questions in front of the judge. Well, the ad litem walks in, and they're like, well, actually, there's other children. And they're like, what do you mean there's other children? There's only us. And they're like, well, no, I have them here. They're in the back of the courtroom. And our client's like, I'm sorry, what? And our attorney is definitely like, I'm sorry, there's only these kids. So turns out that the ad litem had talked to the stepchildren, and they had said that they thought that, that this was actually more than what it was on paper. Pretty much that the decedent represented them as their children, that he treated them the same as his kids, and that they deserved a share of it. And so, well, you're sitting here, Morgan's sitting there in open court, and she's like, well, no. And the judge is like, okay, well, we're setting this for trial. We are not going to proceed today. We don't handle, things that actually go to trial. So Morgan takes our client, the other siblings, air quotes there, out into the hall and starts talking to them. And there's this just full out like fight that ensues in, I believe it was like Denton County.
Mhm.
And turns out like the night before they'd all gone out to dinner. No one had said anything. No one like
Wild.
had mentioned that, oh no, we'll be there tomorrow and we're gonna show up and say that no, we're his kids too. So that was a beautiful time for Morgan.
Morgan.
By the way, this won't sound related, but it's always concerned me that the Dallas County probate courts don't have any metal detectors or security when you go into the building.
That's crazy. I'm surprised they don't.
For family law, there's metal detectors everywhere.
Yeah. Yeah, because clearly you never know who can necessarily show up. So that's stuff that happens without a will. And then some other horror stories we have is when people attempted to have a will. Why don't we talk about a few of those attempts? What's a favorite of yours?
Oh, we all know
Cyntia?
my favorite. This one was one, oh gosh, it was years ago that this was brought to us.
Is this the zero shares one?
No, this is a different
Oh,
one.
that's my favorite.
So yes, the zero shares one is is there, but no, it's one of the holographic wills that was brought to us. So for those who don't know, holographic is a type of will that is
It's
written
where it's
solely.
like Princess Leia, where you can't really see it, right? But it's like,
That's a hologram.
oh, never mind. That's not what a holographic will is. That'd be cool
Nice
though.
try.
Also, did you say Princess Leia, not Leia?
Ooh.
Ooh, yeah. We'll just have to move on past that and
Oh.
save that for another time.
Okay, so holographic will. Okay,
Is it
so
Han or Han? And who shot first?
why did I do this?
I don't know.
Wow.
I didn't know where that was going. Anyway, go
Was-
forth. Probate.
You
Your
just keep
favorite.
Kimberlying me. Oh my gosh. This is what you feel like all the time. Okay. So, holographic will, written solely in your own hand. Contrary to popular belief, please, this is not a substitute for an actual will. This is something that should be emergency only. This should not be something that you go to and you're like, okay, good, we're done. No.
Yeah.
So, years ago, we were brought this will that was written by the wife brought it in. Her husband had written this. And throughout the document, there's only one complete name, and it's the testator's name. So the person who has now passed away, the husband, he signed at the bottom. And so that is the only place where we have a full first and last name. Throughout the documents, there's a lot of names sprinkled about, but we really don't know exactly who is who. Typically in a will, you have the name of the person who's making the will. You identify people, such as if they have a spouse, if they have children, if they have anybody whom they're excluding. So typically those are the things that you really need to ensure that you have. Well, this person, no, they just went in and said, this is my will, and I leave everything to my children if my wife, Jane, does not survive me. And then goes in and lists some specific properties to go to, depending to who, what have you. So this is something that's really, really great because it gives us two things. One,
It's
It's
not
so
really
great.
great.
it's a great
So
learning
great.
experience. How about that? So the biggest thing is, well, one, it doesn't say what happens if the wife does survive him. This is just stipulating if she does not survive him. And this really illustrates the second great thing is how people think in the state of Texas that everything is automatic and everything goes to your spouse. Because the wife came in, she's like, yep, he's passed away, so I get everything, and then here's his will. And we're like, this will says if you do not survive, everything goes to the kids. Nothing here states what happens if you do. And she's kind of stared at us. And it's like, well, there's nothing we can do to change things. So this is a will. This is what we have.
Bad time. That's not my favorite.
It's not your favorite, but I feel that's a really good one to illustrate the biggest misconception people have in Texas.
And it's hard to pick a favorite, really, but the one that comes to mind is the one where it was a DIY job, which 90% of the time they don't even get signed correctly, so we can't use them at all. And then every once in a while, they get signed correctly, which means we have to use them, and it makes things worse. And I'm looking at this will right now. This is when we actually had to probate, and it reads, I direct my executor to divide the residue of my estate into I'm not gonna be able to get through this, into 100 equal shares, which will be distributed as follows. It lists a name, so I'll just say name one. Even though this is a public record, we could share the names, but we won't. Name one will receive 0 shares of the residue of my estate, and name two will receive 0 shares of the residue of my estate. Now, Sam, you're somewhat of a math genius. We started with 100 equal shares.
Mhm.
How many shares have we given away?
0. Ooh. Maybe they're just being petty.
Which I'm all for petty.
Hold on, but it gets better.
I'm all for petty. And you must be thinking right now, those of you at home, dear listeners, certainly then it says who the 100 shares go to. It does not. Not really, because the next paragraph says, or reads, provided, however, if any beneficiary and any alternate beneficiary, if one was appointed, shall die before becoming entitled in accordance with the terms of my will. Entitled to what? To 0 shares? The whole that share shall be divided amongst the remaining beneficiaries who also receive nothing. Then there's this thing that I have never heard of before called a wipeout provision. Oh, wipeout. Anyway, wipeout
Song.
provision. Should my spouse predecease me, oh, spoiler alert, they did not. So
Well,
then what
hold
do we
on.
do?
It's a little ambiguous.
Or fail to survive me, and I leave no children, child, grandchildren, or grandchild surviving me, which, by the way, they did. There's a whole list of kids that survived. Then I direct my executor to divide the remaining, and now we finally have 100 shares to someone named. But I don't even know how we get to that person at this point. Another favorite part of this is the executor provision. And what page is that on? I'm looking for it right now. Is that
It's a little
before this
further
says?
down.
No, it's up.
Wait, no, it's
up.
at the top.
Yeah. So again, we can disclose the names because it's public record, but we won't. But we'll just say executor 1, executor 2. So this is the actual executor appointment. I appoint executor 1 and children of Frisco, Texas, and executor 2 of Frisco, Texas to be my executors. So are they saying executor 1 and all of their children? And by the way, why would you need that many executors and plus this other person? Or are they saying executor 1 and all of my children, like their children? Like what? Who does this? I don't even know. What are some other good ones from this?
Well,
Is this
hold
one
on.
where
And this,
family members were witnesses? No, we didn't do. That's not this one.
I don't remember, but one of the things in this will is that the testator said, okay, so they have something in here for minor beneficiaries, pretty much intending that anything that goes to a minor shall be kept for them, safe to where once they reach a certain age. So in here, throughout the document, once we get to that section, it keeps saying to be distributed at an age set by me. So I reread this to be sure before we started recording today, and nowhere in here did they set forth an age. So even if we do figure out how the distribution actually happens, and if there happen to be minors that get such monies, we don't know when to give it to them. It just says designated age at an age set by me, and it's like I kept reading just to be sure, and no, nowhere.
Yeah. It's bad, everybody. This is bad stuff. This is bad stuff. So let's take a break from horror stories, although probably not, and let's talk a little bit about some myths. Sara and Sam, have you come up with some myths about probate that you thought
We
were
have.
interesting to talk about?
Yeah.
Yeah.
We have a couple. Cyntia already mentioned them. Some of them.
I did.
Yes. Thank you, Cynthia.
It's okay
I
because
didn't read your thing.
So
So salty.
it comes up. It comes up
yeah,
repetitively.
it comes up.
So
There's a
it
reason they're
helps.
myths. So one of them was that you don't need an attorney to navigate the probate process, which is the one you mentioned.
I like to point out that's the last one on their list.
It is, but because you mentioned it, I was.
Look, I knew there was going to be some redundancy here,
Yeah.
and that it takes people what is it, like 9 times to hear something before they retain it. So there's at least 7 more times that you should bring this up.
Very true.
Just not in this episode.
Sara, do you want to take the next one?
Yeah, so a common misperception is that if you have a will, you don't have to go through probate or worry about it, but you do.
Sara, this is a huge one. This really is a huge one, and I think it's one where when I'm doing presentations, I always like try to stop people in my tracks. Like, no, wait, did you hear what I just said? Because it is something that we get a lot of. We'll get someone who calls us and says, my mom passed away. She has a will. I'm the executor. I need to know where to start. And it's like, no, you don't have a will until a judge says that you do. And nobody's an executor until a judge has decided and appointed that you can serve as the executor, which means that you have not committed any crimes of moral turpitude, that you are of sound mind, and you're at least 18 years of age. It used to be you also could not have convicted a felony, but they've relaxed that requirement in the past. And so, yes, a will does have to go through a probate court process. Now, we kind of went through in probably more detail than I really should have. So hopefully people are still listening, or maybe Sara will edit that part out. Who knows? But anyway, what happens, like the whole determination of heirship process? Well, a will still has to go through some of that. So basically, there has to be an applicant. Typically, it is the executor, although technically, it doesn't have to be the executor. But let's just go with what happens most of the time. The executor is the one who has to hire the attorney, right? Everybody hire the attorney. Okay, the executor hires an attorney. We file an application for probate and have to wait. There's a statutory period of time. It amounts to like 10 to 14 days essentially before you can schedule a hearing. So there has to be notices and so forth. But that's not necessarily how quickly you get a hearing, because there's court schedules to contend with and everything. So you go to the hearing, executor says, yes, person passed, this date, that, blah, 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 blah. And then the judge then says, okay, this is a valid will. You can serve as executor and you're on your way. Now, that's a scenario where all T's crossed, all I's dotted. Obviously, we've talked about some wills where that was not done. But a will that really has everything taken care of, that is how that would go. And then the executor is appointed and they can start doing the things they need to carry out the terms of the will. There's a few more requirements that have to be met for the court and the filings, which is one of the many reasons they require an attorney to go through the probate process. There's an inventorying of the estate. There's notices to beneficiaries that have to be sent, which, by the by, a lot of people will say, well, I want to leave $1 to someone. So talk about 0 shares. It's actually a smarter thing to do if they had given away their 100 shares to somebody. I actually, our general rule of thumb, and again, this is specific to Texas, is you can completely disinherit somebody. And we actually make the argument that you wouldn't do the dollar or $10 as much as I do. I'm all here for pettiness. I really am. But because you're requiring then for your executor to send that person notice, you're requiring for the executor to send them a copy of the will and all of that. And sometimes it can be hard to find the people, like you disinherited them for a reason. And so it's better just to say this person gets nothing. That's general. That's not advice to every specific circumstance, but just some general thoughts, because that's another myth that neither Sam nor Sara probably thought to ask. But that's another myth
No.
that comes up. But yes, and so probate right now in Texas, as long as there's no issues with the will, there's no issues with family and delay and everything, then that can take, or that can cost around $3,500 on average still. And it can take a few months before you can get started. But so that's still a lot less expensive than nothing. It's a lot faster than nothing. But if you're really following along, the will is going to make the decisions that you wanted. Who's going to be your executioner? Oh, I'm sorry, executor. Who's going to be the beneficiaries who get 100 shares, not zero? It's not the state of Texas deciding all those things for you. So a will is absolutely the bare minimum of a recommendation that we would provide to people. But as Sara so astutely points out, it's almost like we have marketing messages around this. A will does still have to go through probate to be a valid will. All right. Sam, you got a myth?
Yeah, I do. You kind of mentioned it, but another myth
Sorry.
is that, how dare you, that every probate takes years to complete, which isn't true. I mean, because of COVID, it does take a little bit longer still, because courts got delayed and everything, but it does, unless it's a special circumstance, it does not take years.
Yeah, and actually you bring up a nuance that I think my new headphones are being delivered right now, by the way, by Amazon. It's okay. Next episode I'll have
Next
my
podcast.
new headphones. I think that's
Not
what's coming
sponsored.
up. What'd you say? Sponsored?
Not
Hashtag
sponsored.
not sponsored.
Not sponsored.
Hashtag ad.
Anyway,
Okay, this part's gonna be edited out, Sara. Thank you.
I think we can
Sponsors.
probably mention Amazon. You mentioned Boeing. Like, did you edit all
Hold
that
on,
out last
that
time?
was different because last time we were asking for manufacturers and listing things, and that was just listing. That wasn't like I
You
was.
mentioned dangerous trends, and Sara said Boeing.
Amazon, if you're listening,
Don't sue us.
please pay us for ads. Thank you.
What do you mean if they're listening? Of course they're listening.
When they're listening, you are listening.
Our
She
podcast is
has-
on
Please.
Amazon.
I have an Alexa right here.
That's what I was gonna say. She has a thing
True.
that's listening at all times. Well, hold on. It can't hear us. It can only hear you.
True.
Can it? Are you sure?
No.
Yours is on the other side of the wall, so.
Alexa hears all.
My parents' Alexa started
No,
laughing.
stop.
Oh my
Stop.
gosh, Sam.
Okay. I don't even remember what I was talking about now.
Probate takes years.
Oh,
It-
so
It's not.
good thing to bring up, because I want to make sure we talk about the timeline here, because what does that mean? So there's the initial piece of getting to court before the person, the executor, administrator, whoever is going to do the things, administer the estate, before they can start, which means accounts are frozen. You can't sell or transfer a bank account. So realtors, listen to this, because we work really well with realtors, that if you're in the middle, like someone's passed away and you're in the middle of closing the house, it's not the time to contact the probate law firm when you're 2 weeks away from closing. That needs to happen immediately before you put it on the market or any of those things, because you are not going to have an appointment or an ability from the court in order for anyone to actually sell that home. And so the first time period is getting to the court and getting someone put in charge as far as what the distribution is going to be, or if there is a will, getting to the court, having the will approved, the executor getting appointed. That's time period number 1. Then time period number 2 is really up in the air, where how long will it take the executor to go to the bank, get the life insurance proceeds, set up trusts for minor children, sell a home, sell property, figure out the mineral interests that are in 5 different states. I mean, it depends. So that's why, on average, what we see, no, it doesn't take years and years, but it could take years and years in order to actually divest of all and distribute all the assets. It absolutely could, but the idea of the actual court process is usually wrapped up within a few months or so. And then that's when you don't need a lawyer, and we would like all the people to not need us. It's like, we got you through the court process where you have to have one. Now you go deal with all of this. I mean, if you want to pay us lots and lots and lots more money, then we can make that happen. But basically, you're now empowered to go and deal with banks, financial institutions, title companies, and whatnot to make that happen. So that's a good myth. Are there any other myths that you were just dying to bring up?
We have 2 more. Sara, if you
Oh,
want
we don't have to do all of them, but by all means, share.
Okay. Next one is if somebody dies without a will, that the state of Texas gets everything.
No, the bank gets everything, right? That's another one that I hear all the time, especially with homes. Who owns the house if you pass away? The bank. Ha ha ha. No, so let's make a distinction between, if you don't have a will, the state of Texas has one for you. So it just means they're going to make the decision. So Texas does not have what is called a laughing heirs statute. Some states do, where if you can't find a relative within a certain degree of relationship, then they would cut it off and the assets would go to the estate. Texas, like the Energizer Bunny, will keep going and going and going and going. So the idea, I really like the name of this, or it's really a nickname for this type of statute, is that someone so remote from the person who died ends up inheriting something that they're laughing because they barely even knew or didn't even know they existed, right? You get it now? Now, what does happen is we have unclaimed property, and that is where things can get turned over to the state. And then you have to go through a lot of hoops and all of that. Ooh, actually, I didn't look at I'm going to see if the 4th myth is one that I was about to cover, because I don't want to upset Sam. But if you don't bring this one up, well, she has red hair, and you can't upset gingers. So
No.
just a rule of thumb there. And that is not a myth.
She'll
Boy,
come after
Sam's
you.
got
I
a
will.
temper on.
She'll be in your walls.
I will be in your walls.
That is a direct quote. Do I know
Okay,
what that
all right.
means? Not completely sure, but she'll be
I
there.
don't want to know what that means, is really the most important thing. But anyway, so I'll just stop there, because I don't want to go down the road of the last myth that Sam wants to bring up. So what is that one,
Yeah.
Sam?
This one I actually hadn't heard before, but that the oldest child.
Where did you come up with
I
this?
Googled.
I actually have heard this one.
Nice.
Do we not have enough experience under our belt to just be able to draw on what we've seen?
Well, I wanted more than like 2 of them. Like, I wanted to make sure that I had enough for this, You never know.
Okay.
Threaten Sam with a good time
True.
is, just tell her to Google something. Tell her to
I'll
find
just keep
information.
going.
This is in between her perfecting her flapjack recipe.
Yeah. That's what I'm doing in the Burch Law kitchen. It's just thinking.
Which kitchen? We have 2. Okay, go ahead, Sam.
True.
What's the
Okay.
last one?
That the oldest child has to be the executor of their parents' estate.
What decade did you look this up in?
These were from like 2020 to like
Let's see.
2023. Like, a whole bunch of articles had them, interesting enough, which most of them were from law firms as well.
Okay. Yeah, so no.
Yeah, no.
But here's that is a good segue into, some people think that it's very interesting that you can't your executor can't be anybody who is a beneficiary. So if you're going to give everything equally to your 3 kids, then none of them can serve as your executor. And that's actually not true. Of course, it's very specific advice and guidance to the individual who is getting their plan put together. But sometimes I'll make the general argument that probate is not fun to go through. I think we've made that clear. If there's any
Yeah.
takeaway from this episode, hopefully it's that. And anyway, that if you pick someone who actually is going to get something, they are all the more motivated to actually go through the probate process. But with that said, there's plenty of people who they need to pick a third party or a friend or someone to have because they think their kids are all going to fight or something, and they need to have that insulation there, and that's fine. They can get fees, they can get paid for their services, and that's a real thing. So the one that I was going to that I wanted to mention, I don't know if it's really a myth or not, but it's more a misunderstanding. You have 4 years from the date of death, and that seems to be important to bring up to people. 4 years from the date of death to probate a will. So if someone has passed away and 4 years from date of death have passed and you have not probated their will, it's presumed the will is revoked or didn't exist. And it is a mountain to climb, if not an impossible mountain to climb, to get over that. And so I maybe this is a good place to wrap up beyond final thoughts that the rest of the crew have, is that the best advice we can give people is that if someone has passed away, have a consultation with a probate. If it costs money to have that consultation, it is worth it. It's actually probably even better because they're going to take you more seriously. They're going to look more into the family, what were the assets, if there is any sort of will or not, and look at it and review it. Far too often, we have people come to us when they have finally found out, oh, there was this account. Oh, there was this life insurance policy. Or there was this stock. Oh, we kept paying the taxes and mortgage on the house, so nobody told us the title wasn't clear. And now we're dealing with a lot of problems. And you not knowing is not a compelling reason to any probate judge that we really deal with. And so don't take the advice of your bank, your financial planner, your best friend's son who's in his first year of law school in another state, or you get the idea. Get the advice from an experienced, qualified probate firm that is in your state. Whether it's a complimentary consultation or a paid consultation, do it, because the majority of the time you're going to find out that there is something that needs to be done, or at least you will have the peace of mind knowing that these are the things to look out for if they come up. Maybe you should do some research, go to the unclaimed property in every state the person lived in and see if anything is there. You're going to know what you might be facing, because more often than not, there is going to be something that will come up. And sometimes if there is a will, we've done this occasionally, where we go ahead and probate it. So it's already recorded by the court, approved by a court. There's an executor just in case something pops up, as it quite often does. So with that, Sara, Sam, Cyntia, there's some synergy with Sara, Sam, Cyntia.
Really?
Any final thoughts on this that you'd like to contribute?
Get a will
Get a
Blank
will.
stares. Or
or a
something.
trust.
Yeah. Now we didn't, and maybe actually, maybe the next episode will be better to talk about ways to avoid probate. Actually, that's what we should
Yeah.
probably do.
Yeah, because I'm with
Next
you. This is like, there's a
episode,
lot we have.
we're going to talk about ways to avoid probate, and just let me, what is this where you teaser, here's a teaser for you, is that we mentioned trusts, and there are revocable living trusts that sound really fancy, and they're not, though. And this is a great vehicle, not a one size fits all, but for people to possibly avoid probate. But, and we'll talk about this in the next episode, if you don't get assets connected to the trust, then you're still going to end up in probate. So when we mentioned earlier, or I mentioned earlier, even if you have a trust, you might still have to go through probate. That is what I was alluding to. So there's a little teaser for you to join us next time to find out, what does that mean? Okay. So with that, thank you for joining us. Please tune in, share with people. This is important knowledge. It is specific to Texas, so share with your fellow Texans, and we'll see you next time.